Now joining us for analysis on today's judgment is Elton Hart, an attorney from the UJ Law Clinic. Elton, good evening. Thank you very much for joining us on the program. Now, that not guilty verdict, I can safely say, has left many activists dejected. You can just hear in those video clips. Today has been viewed in some quarters as a dark day for women and the pursuit for justice for violated women. But if we had to shift gears and focus on the judgment itself and some of those remarks against the NPA, essentially we heard today Judge Irma holding the view that the state did not acquit itself well here, essentially failing the victims. Your take?
No, indeed, she made a couple of scathing remarks directed at the NPA. And my problem is already, when I look at this from a practical perspective, when the first prosecutor, Ntelwa, was on the case, he let the witnesses, the complainants, to actually take their statement, to give their evidence in court. And he was the lead prosecutor at that stage, leading them. And in his head, he surely had a plan as to how he would go about leading the evidence and then lead it in such a way that he would then have points that he can actually put to the defense witnesses under cross-examination. Now, the problem comes in, and I think little is being said, there was a change of hand of prosecutors. And this was at some stage at the behest of the complainants themselves. So now you have a change of prosecutors, and how Ntelwa looked at leading his witnesses compared to how the cross-examination goes down, because it's now two prosecutors with different game plans. And I think that already was one of the things, a misstep on the side of the prosecution, to say that we have to change the prosecutors. And I understood the reason why one of these prosecutors, the main lead prosecutor, was removed, is because of irregularities and his conduct. And that led to him being removed. But then they could have most probably get a transcript, have a proper discussion in their office and think who's the person best placed to actually follow on the evidence in chief, to actually direct their cross-examination, to bring the points in dispute, and then actually cross-examine the witness on the versions that was placed before court by the complainants.
But Elton, many would think that's, pardon me for interjecting there, but Elton, that part of the transcripts, many would think that's very elementary. Everybody in the legal space would know that if anything, you will make use of those transcripts. So I take it, even if there was impropriety on the part of the first prosecutor, that there was a transcript, we've got everything in court documents, one assumes that they read through that but still took the decision not to cross-examine and not utilize those 9 days. So that is what baffles many. Is this now due, or what does it speak to? Is it inexperience or an honest wrong call here?
For me, it's a wrong call. It can be inexperience, but also two legal practitioners, when they tackle a case, normally we have the same tools in our arsenal, but we just choose to use it differently. And that might have been the case where one prosecutor thought, I don't need to actually cross-examine the defense witnesses to such an extent, because they were relying on what they call similar fact evidence to say that a lot of these witnesses said the same thing. But not understanding that rule is to say, yes, a lot of witnesses say the same thing, but it just proves that this offense or event occurred, but it doesn't prove it beyond reasonable doubt to say that this is a crime that was committed by this person. It speaks to the identity of the person who committed an act, but not really that it's a crime that was committed. So that rules of evidence, and you can most probably attribute it to inexperience, but I can also say maybe it's just a misjudgment on the prosecutor side to think that if we change this person and bring a person in at a very late stage of this trial, he would be in a position to actually fully verse himself well with the content of what has happened over the past 5-6 years in the case. And I thought that was a decision that was most probably, they had to get somebody on the case with the lead prosecutor back then as a second chair that would have followed the proceedings, I think, especially in the high profile cases. And I think maybe there was the calculation error on the side of the NPA, but also the lack of proper cross-examination that was highlighted by the court. And also the other conduct of the lead prosecutor back then as to how he sort of half told witnesses. And I think that is where the judge came in to say, but the fair trial rights of the accused is already somehow harmed in the previous conduct, and then although she doesn't believe the accused version subjectively, but looking at it holistically, the doubt needs to be given to the accused. And that's how our system is geared, to say that when there's doubt, it's given to the accused and not to the complainant.
So essentially here, as we've heard as well from the NPA, that the acquittal was based on a technicality, but now they're exploring other avenues. What avenues do they honestly have in this respect, if you're talking about procedural unfairness in this respect, and saying that in such a case then it would favor the accused in this respect, especially because it's been 8 years? So what options do they have?
The only option that they have is to appeal the judgment. But now, remember, when you appeal a judgment, you are bound by the record. You stay within the confines of that record. And if they did not place something on record, then the hands is a little bit in handcuffs. Because remember now, the accused versions was not properly tested under cross-examination.
Yeah.
They did not even have to bring corroborating evidence to say that my version is corroborated by this witness as defense team to bolster their defense. They did not have to do that because the cross-examination that was put on the table by the NPA was of such nature that it did not actually say beyond reasonable, or that the accused version should be rejected outrightly. And that is where the judge then made that balancing act to say, listen here, if I have two mutually destructive versions, and then I need to look at which one is possibly true. And she even averred to it to say that subjectively, I don't believe the accused version, but in the bigger scheme of things, I have to give him the doubt because of 1, 2, 3, and she mentioned the reason to say the irregularity, the lack of corroboration between the complainant's evidence, and she even highlighted where you have a point where is the first report. Remember, in rape cases, normally you have a first report just to say that this has happened, not to say that it's true. The first report is normally just to say it happened, and then you look at also the SMS and telephonic contact between the complainants and the accused, and that evidence or persons to come and testify was not even brought. And that was also a misstep by the state not to call these witnesses, which means that the lack of corroboration just became bigger. And based on all those things, the judge didn't think beyond reasonable doubt she could convict. And I think the uphill battle would be for the NPA now to go and appeal this judgment with that limited information on the record.
Sure, because they cannot introduce new facts. Most certainly the NPA tonight has broken a lot of hearts. Elton, thank you very much for that analysis. That's Elton Hart. He's an attorney from the UJ Law Clinic speaking to us there.